Welcome, everyone, to the second day of the Animal Law Symposium, Protecting Animals Through Transparency, Engagement, and Regulatory Practice. My name is Caitlin Hawks. I am the Chief Programs Officer here at the Animal Legal Defense Fund, where I oversee all of the organization's legal programs, so litigation, legislative affairs, criminal justice, animal law education and scholarship, pro bono, and finally, our newest program, Transparency and Regulatory Affairs, whose areas of focus have guided our topic selection for this year's symposium. So thank you for joining the ALDF for this two-day virtual event designed to deepen the understanding of animal law and provide legal professionals and advocates with tools to advance animal protection. A few housekeeping comments before we get started. First, all sessions feature closed caption subtitles. In order to enable this feature, you'll click the upward arrow near the CC button at the bottom of your screen and select Show Subtitles. You can enter any questions you have in the Q&A box that you'll see at the bottom of your screen. I'll do my best at the end of the presentation to get to as many of the audience member questions as I can. And then finally, the symposium is being recorded, and so the recording will be shared with you later via email. We have a poll that should have just popped up on your screen. Please take a moment to answer the poll question. If you're seeking continuing legal education credits for this session, please click yes. Attorneys seeking credit will receive information via email after the symposium concludes. Okay, great. Thank you. Now on to the panel. This panel is entitled Expert Witnesses in Animal Advocacy, and it explores the critical role that expert witnesses play in civil litigation and criminal enforcement actions to protect animals. Our panelists today are Chris Caraway, who is a staff attorney with the Animal Activist Legal Defense Project at Denver University School of Law. Marcus Hasbin, who's a partner at the law firm of Zuckerman Spader, LLP, and my former co-counsel on a number of captive wildlife matters. And finally, Will Lowry, founder and legal counsel for Animal Partisan. I'm very excited to hear their perspectives on criminal prosecutions, wildlife and endangered species cases, and challenges involving animal agriculture. The discussion will cover how experts are selected, prepared, and challenged, as well as best practices for effectively using expert testimony to advance animal protection goals. We're going to start off with short presentations from each of the panelists. So I'm going to kick things over to Chris first. Chris, please go ahead.
First, I want to thank Caitlin for moderating this, my fellow presenters, and everyone at ALDF for having me, and especially those working behind the scenes to make sure this weekend runs very smoothly. My name is Chris Caraway. I am the staff attorney for the Animal Activist Legal Defense Project. I perhaps come at this from a really unique perspective because most of my practice at the Animal Activist Legal Defense Project is criminal defense. We defend animal rights activists who find themselves in a courtroom, primarily in a criminal courtroom, because of their advocacy. Our project also does a varying degree of First Amendment litigation and civil investigation and whistleblower defense, but we do a whole lot more. I've worked with Will on motions for special prosecution, and we've done that in Wisconsin for Ridgeland Farms, which we'll talk about in a moment. My background before I'm at AALDP is I was a public defender in the state of Colorado for 10 years, where we often used expert testimony ranging from misdemeanor cases all the way to first-degree murder cases. So the few things I want to talk about in this sort of brief presentation, because I want to make sure we have a lot of time for credits, is first, why experts? And I think this quote from a juror we had in our first trial, a rescue of 2 chickens from a transport truck outside of Foster Farms, is really helpful. This juror, who we interviewed after our 2 clients were acquitted for rescuing 2 chickens, Jax and Ethan, said this about our expert, Dr. Kirsten Rosenberg. I won't read it word for word, but generally she said the expert, Dr. Rosenberg, was the best witness. The juror gave a lot of weight to just simply the fact that she was qualified as an expert by the judge, who the jurors gave a lot of credit and faith in. And I think the last paragraph is really the most important part about the impact of expert testimony, is that you can take really complicated concepts and dumb them down, and for lack of a better term, for jurors to understand. And sometimes this is difficult in animal cases because the cruelty and the harm to animals is so visceral, is so obvious. But sometimes having an expert really explain just how that animal is suffering, how that animal is feeling pain, and what should be done and what is not being done, that provides that deeper understanding and the authority for the jurors to really feel outraged about what they're seeing happening to the animals and empowered to try to do something about it, whether that's, find someone guilty of animal cruelty, or whether that is um, throw support behind an activist who rescues an animal from situations of neglect and cruelty. And I think another great example is Ridgeland Farms, which has been in the news recently for a variety of reasons. But Ridgeland Farms, at least the project's involvement started way back in 2022 as one of our first cases where we were defending an activist who went in with two others to investigate and ultimately rescued three beagles. The state prosecuted them, and on the eve of us arguing some important motions, namely that animals aren't just things, they're beings that deserve rights and affirmative defenses, the state dismissed. We turned around pretty quickly and filed a motion for special prosecution. This was something that Will gave us some really important insight on, as well as the folks from PETA. And during a one-day hearing, we presented expert testimony from animal behavioralist Mark Beckhoff, as well as Dr. Rosenberg again. We also relied on expert reports. Stacy Lopresti Goodman was super valuable, especially with her background on researching dogs and just the impact of testing. And all of that was included in our petition. And that ultimately persuaded the judge, Rhonda Lanford, to find that Ridgeland Farms had committed indeed felony and misdemeanor animal cruelty, appointed a special prosecutor, which resulted in Ridgeland Farms giving up their breeding license in a matter of 2 months. And the judge, in her ruling, specifically credited the substantive testimony of our experts. And I think that's pretty impactful because you can look at the footage of the dogs acting psychotic in the cages because of their conditions. You can see the photos of their injuries, and the harm seems really obvious. But again, it was the expert really providing that deeper foundation with some authority that helped persuade the judge and often will help persuade jurors. And when you think about like what do I need an expert in, I like to start from like a really basic question. What do I want to explain to the jury? And that can come in a variety of ways. And I want folks to kind of have a broad scope of what do I want to explain to a jury that can be explained by someone better than me as the attorney. Because that comes with a lot of benefits. One, there's the sort of separation from the attorney as advocate, which has some scrutiny from fact finders because obviously we're zealously representing our clients. Two, it has authority. I'm not a vet. For instance, I can't speak with authority on a lot of these topics, nor would I attempt to. So, for instance, what we've done is we've had the standard testimony about animal suffering. On the left is a report we had from Dr. Contreras that we were using in our case involving Zoe Rosenberg, who rescued chickens from a slaughterhouse. On the top right, we have used experts who gave legal opinions on when it would be appropriate to rescue animals from situations of abuse. Specifically, such legal opinion was our path towards acquittal in our Foster Farms case. And then in the bottom right, we spoke with Cheryl Leahy, who gave us a great expert report on the lack of animal cruelty enforcement, particularly in the state of California, which was impactful in terms of trying to argue the futility of simply reporting animal cruelty to the state and justifying when people take action into their own hands when no one else will act. So it's important to start from kind of that like broad base perspective, um, from a sort of really fundamental aspect. So with that all being said, I want to end this brief presentation so we have time for questions and our other presenters.
Great. Thanks, Chris. Marcos, I'll turn it over to you next.
Okay, thank you, Caitlin. Hopefully everyone can hear me okay. As Caitlin mentioned, my name is Marcos Hasbin. I'm a partner at Zuckerman Spader. We are a DC-based firm that has a Tampa office, and I've been in the Tampa office for 26 years. We are celebrating our 50th anniversary this year, and I'm very proud of the opportunities that I've had to work on animal rights cases, many of which have been with Caitlin and also Brittany Pete, who is now at ALDF. And I'm really happy that I was asked to have an opportunity to speak here on this issue. So, the importance of experts, as you can imagine, can't be understated, especially in these types of cases. A lot of the way I characterize what an expert's role is, it's to teach the fact finder what they don't know. And there's a lot that fact finders, whether it's a jury or in the cases that I'm going to talk about, judges don't know, and it helps them reach decisions on critical, issues of critical importance in the case. And just I, in working on some of these cases, have learned so much about animal welfare and what animals need. Things that, just as basic as what kind of nutrition do they need, depending on the species? What kind of enrichment do they need? These are things that your average layperson might think they know about, but they really don't know about. And that's where the expert comes in. And I want to talk about a case that Caitlin and I were co-counsel on a few years ago. It was an Endangered Species Act citizen suit case where PETA was the plaintiff together. Well, in the first case, PETA was the plaintiff against a roadside zoo in Maryland that the bulk of the testimony, it was a 6-day bench trial, was primarily expert driven. There were some fact witnesses, but for the most part, what the court relied on in finding that there was a take under the Endangered Species Act was the powerful and impactful testimony of the two experts that we presented. And there's a quote here from an article by the zoo's attorney. "I agree that the judge's findings of fact don't look good based on the unopposed testimony from PETA's experts." There's two sides to that. It's not just that the PETA's experts were really good. It's that we were able to exclude the zoo's experts using Daubert motions and motions practice to convince the judge that their experts weren't experts. They were experts in name only. They didn't have the substantive expertise to testify on the subject matter. They didn't have sufficient basis to on which to render their opinion, and the judge excluded all of them. And that's a critical pretrial win in order to convince a trier of fact that, you're right and they're wrong. And that's what this is all about. If you have access to Westlaw or the law library, you can check the case out. People versus the Ethical Treatment of Animals versus Tri-State Zoological Park of Western Maryland. It was, like I said, it was a 6-day trial. If you have time to check out the opinion, it's great. It's a very comprehensive opinion. It was precedential setting in certain respects, including, I think, finding that the lack of enrichment for certain endangered species constituted a take. There's embedded photos of some of the trial evidence of the conditions that the animals were kept in that are in the opinion. It was a fun case to try. PETA, we had two experts. One was a former zoo veterinarian with big cat and lemur experience. And why that's important is it's not just important to get an expert that's a veterinarian, for example, but a veterinarian that's an expert or has experience with the species at issue. And in this case, there were the animals at issue were 9 endangered species. At the beginning of the case, when we first filed the suit, was 2 lemurs, 2 lions, and 5 tigers. By the time we had the trial, 4 of those creatures unfortunately died due to the conditions at the zoo. One was transferred, and we needed a veterinarian that had experience with both big cats and lemurs, and this veterinarian was great for that. And we also had an animal husbandry expert who was basically an animal behavior expert who was currently employed by a zoo who also had the relevant experience. And I'm going to go through the opinion and some of the things the judge said in her opinion to show how important, how critical it was to have experts who know what they're talking about, who are credible, to help the finder of fact reach the conclusions that they did in this case. And obviously we won the case. We got an injunction, a declaratory judgment, and the animals that were at issue were transferred to much better places where they're living their best lives. So in this opinion, the judge, like I said, cited to the expert's testimony multiple times. And this is one quote from the opinion. Tri-State's pattern of waiting until animals are very ill, very, very ill before either bringing it to the attention of the veterinarian or until the veterinarian actually comes out to look at the animals has, according to PETA's experts, contributed to long and painful deaths of 5 endangered species. This is another quote from the case. The court credits the testimony of PETA's animal husbandry expert, Mr. J. Pratt, who over 25 years of training, education, and experience aided this court in its fact-finding mission. As Pratt opines, defendants exhibited a stunning ignorance as to how to provide the lemurs an environment remotely appropriate to their species. Pratt found that defendants did not have any process, information, research done into how to alleviate these problems, let alone that they were even aware that they were a problem to begin with. And I'll give you just one example of the many data points that this particular expert gave to the judge about lemurs and stuff that no one but an expert in the area would know of. The way the zoo was configured, the lemurs were in an enclosure. It was 2 lemurs in one enclosure. They had the same type of enrichment, if you want to call it that, for their entire tenure there, which was years, the same toys. But one of the things that he described was the lemur enclosure was right next to, I think it was a wild dog enclosure, Caitlin. And the way the expert described it, he said, you were putting these lemurs in sight vision and in smelling, because the lemurs are very smell sensitive. They use that as a communicative tool in close proximity with a natural predator. So it causes them to be in a constant state of stress, and can lead to a lot of these conditions that one of the lemurs, unfortunately, was so stressed out. Our experts opine that he mutilated his genitals as a byproduct of his constant state of stress. That came in through the expert testimony. Again, on the subject of lions, the PETA's experts opine that keeping a lion in solitude does not meet commonly accepted zoological practices. These experts were able to explain to the judge what are what a good zoo is expected to do and what standards they follow and what the zoo was not doing, by way of comparison. This quote here is in reference to Bandit the lemur that I mentioned earlier had mutilated his genitals and died. It is also beyond dispute that Bandit exhibited signs of significant distress. Both Dr. Haddad and Mr. Pratt opined that Bandit's ripping at his penis represented a long-term condition due to chronic stress and anxiety. Again, the Pika was one of the lions. She survived. She was ultimately moved. She was kept in a state of solitary confinement for her entire time at the zoo. The experts explained how bad that is, both physically and psychologically, for a lion. Another one of the animals, a tiger, died of sepsis at the zoo, and the PETA's veterinary expert, rendered the opinion that this was likely caused by the unsanitary conditions that existed at the zoo. This zoo there's photos in the in the opinion, if you want to see it, of the state of, for example, the food preparation area for the animals. It was disgusting. And I think, one of the things that's a good expert can do is they can really analogize, and make things simple for the fact finder. And here, Mr. Pratt, who is the behavioral expert, said a lion forced to live in solitude with a single ball for company. This was in reference to Peak, I think. She had one ball for her enrichment. Is tantamount to confining a human in a single room with a single book for years on end. That's all you get. That's the only choice you have ever provided to you if you're a lion at Tri-State. So, if you're the fact finder, imagine you've got one magazine on your coffee table, and that's the only magazine you're going to read for the rest of your life. You're going to go crazy. So, you know, this whole opinion is a 25 or 26 page opinion, is peppered with references to the experts. And in this type of cases involving animals, it just goes without saying, you need strong experts, and you got to do your best to challenge the other side's experts. And if you can get them knocked out of the case, that's a huge win pre-trial. And there's me, and there's my firm. That's it. Thank you.
Great. Thank you so much, Marcos. Will, you're up next.
Great. So just would echo the thanks given earlier to ALDF and the other presenters, and I'll just jump right in. And so I am with a very small nonprofit called Animal Partisan. I won't spend much time on that, but most of what we do is related to farmed animals. We spend about 10% of our time dealing with issues involving animals and experimentation. And one of the big things that we work on, which is what I'll be talking mostly about today, is enforcement of laws. And those would be state cruelty and neglect laws as it relates to farmed animals. And so I'll speak to that, and I know we have a Q&A later, but we use experts in a couple of different circumstances. The first and main one would be these cruelty and neglect complaints. And as Chris alluded to earlier, one of the things we do a lot of is what I would call private prosecutions, where a citizen or an organization is stepping into the shoes of the prosecutor, who in most cases is unwilling to prosecute. And so in those contexts, we are actually prosecuting the case on behalf of the state, and we are using expert witnesses to try to prove the elements of cruelty and neglect. And I can speak to some of those cases. We've also worked a little bit with experts in false advertising cases, experts in consumer perception, surveys, and those types of things. So those would be the different areas where we work with experts. And our expert testimony, I would say, comes in two different forms. Certainly, it comes in the context of a trial. And as I mentioned, these would be private complaints. So we're acting as the prosecutor. We have a veterinarian there at trial who is supporting the prosecution. And I'll talk about some of the things they speak to. But we also use experts in a lot of contexts, sort of behind the scenes, whether that's in the form of an affidavit or a declaration, even to get that case to trial in the first place. And so that's another area where we use experts. As far as some case examples, just to speak to where we've used experts, our most recent one was a Pennsylvania auction facility. This is a small animal auction facility selling chickens, turkeys, goats, rabbits, those types of things. We had a private prosecution trial in Pennsylvania where we brought the auction facility to trial. And we had an expert who was there to attest to lots of the undercover video that was taken. Things like speaking to, why is that rabbit panting? Why did that rabbit just fall over in what appears to be heat stress? What types of conditions should these animals be kept in? We had another trial. This was for a slaughterhouse, a pork slaughterhouse or a pig slaughterhouse. This was kind of I would say, an example of where the expert thing didn't work out. Maybe I could speak to this later. I got a call the night before the trial saying the expert couldn't show. And so I was left with 3 hostile witnesses as our total case. So some lessons learned as far as securing the expert and making sure things are buttoned up. Plainville was a case that we worked with ALDF and PETA on. This was a private prosecution for a turkey, a turkey catch crew. And in that context, we had an expert in poultry who came and spoke to why is this turkey cowering in the corner? What is that the way a turkey's wing should look? Is that the way to handle a turkey? All those sorts of things in pursuit of cruelty and neglect charges. And I think the last one I'll mention, just so we can get to the Q&A, is Wilson Farm Meats. And Chris alluded to this Wisconsin procedure earlier where you can bring a private complaint. This one actually involved a steer at a slaughterhouse whose tail was broken in an effort to force him into the slaughter chute. And so we had two experts write declarations related to this, and it was specifically about the anatomy of the steer's tail, speaking to how tails get broken, how much force needs to be applied. That one actually led to a felony charge that was ultimately dismissed, but for about a period of 2 months, we had a felony charge hanging over a slaughterhouse for breaking a steer's tail, forcing him into the slaughterhouse. So mostly cruelty and neglect complaints, talking about things like conditions, animal reaction, behavior, and those types of things. And then at a super high level, some of the things that we consider, the first one is just because we're a small or we have a very low budget, we don't have the funds to pay an expert $1,000 an hour. And so we need to be realistic about our case and we need to think about what's that expert going to charge. Obviously, experience and credibility. We know questions will come up, especially if we're going after commercial agriculture industries. Do you have experience with an entity this size, or are you just familiar with maybe backyard chicken flocks? And so, do they have the experience? Do they have the credibility? Is obviously a huge question. And then just ease of working with. Is this a person who is going to be amenable to multiple prep calls, updates to sort of the outline, a lot of back and forth on the questions, a lot of follow up? Is that somebody that's easy to work with, even beyond the actual trial or the declaration, just getting to that point in prepping? And then there's obviously a ton of logistics. How do you get to the point where you're ready for trial and ready for this person to testify? So, experts, I would say, are hugely invaluable for us, especially in the context of cruelty and neglect, and happy to have found several good ones. So, Caitlin, I think that's it, and I'll throw it back to you.
Okay, perfect. We're going to pivot now to questions. So first off, a question, I'll start with Chris for this one, but others are welcome to chime in after. So for cruelty cases where the harm is obvious, how can experts be used to further emphasize or drive the point home?
Well, I think Will touched on this very well in terms of you see things like why is this chicken in the corner separated? What does that mean? And I think, the average layperson can look at that and be like, something is not right. And I think on a human level, have empathy. But in order to like really connect it to neglect or affirmative acts of cruelty, an expert can help explain like why that is. Or for instance, you have footage of a non-ambulatory hen inside of a slaughterhouse. And you can have an expert take this one picture, which on its face does not look very good. It shows something bad and something wrong. And that expert can talk about, well, here's why I think this hen can't walk. And here are the problems of that. And this hen is sitting in an unclean environment. So the combination of, potential physical injuries, foot injuries, and the conditions, they can lead to all these complications. So it's a way to sort of really go further with some additional authority beyond perhaps what the investigator who documented that footage is, who oftentimes, unfortunately, is not a vet, or simply the attorney arguing the inferences from that evidence, which obviously doesn't have that scientific background, that authority, and jurors may view the attorney's argument with skepticism because, as I mentioned, we're not objective, we're biased towards our client.
Yeah, that's great. That makes sense. That really, it comes up a lot in the context of captive wildlife, like Endangered Species Act type litigation too, like what Marcus was describing, what we worked on, where, in that case, we were suing under a statutory provision that prohibited a take under the ESA in the form of what's called harassment, and then harassment is defined to be interference with a normal behavioral pattern in a way that inter that or that that it interferes with like the animal's breeding, feeding, sheltering, or other kind of normal behaviors. And so we really needed to rely on experts to connect whatever we were seeing in the evidence in terms of animal behavior, whether that's like pacing or self-mutilating or whatever. And then that had to be connected back to that statutory definition to prove that something unlawful actually occurred. So we had to say this behavior we're witnessing is interfering with normal behavioral patterns X, Y, and Z. And we really needed experts to kind of make that connection for us. I'm going to turn to Marcos next, but everybody else is welcome to jump in response to this question too. Marcos, what are the different roles experts can play in the context of litigation?
That's a really good question, Caitlin. I mean, so people typically think of expert witnesses as actually serving in the role of a testifying expert witness, where they are appearing in court and they're answering questions about their observations and the basis for their opinions. But even before you get to that point, experts can play a consulting role as consultant expert witnesses, and what that is those are individuals who are there to assist the lawyers understand the evidence and understand what some of the strong pieces are and what some of the weak pieces are. And they're really protected in the work product space, so that they are somebody that you can consult with freely and ask questions freely. If you have the funds, if the cases of the magnitude and the funds are available, oftentimes you will have a consultant expert that you work with and siloed from a testifying expert, where there might be information or theories that you want to test out, where if you test it out with the testifying expert, that might become discoverable, and you don't know how the expert's going to respond to that. So you want to bounce those ideas and pressure test those theories with a consultant expert who can tell you, hey, look, this is how I think this is going to play out. This is the opinions that a good expert will likely reach. And if you feel comfortable with that information that you've gotten from your consulting expert, then you can pivot and have a discussion with your expert witness about, what do they think about these particular issues based on this set of facts. And you have a certain comfort level that the response is not going to be something that is not necessarily good for the position you want to take. So if you could, if you can have a case where money is no object, and unfortunately oftentimes it is, but there are cases where um, you have that opportunity. It's a great resource to have a consultant expert working with you in addition to a testifying expert. The other thing you can do is, you don't typically just launch into and identify somebody as a testifying expert. You want to get a sense as to, are they going to be helpful to you, right? You first engage them as a consulting expert. That way, if you find that you don't think that this person's opinions are either going to be helpful or they're not particularly impactful, you can make the decision to keep them just in their role as consulting experts, and they're not going to be able to testify at all, whether even for the other side, and the other side's never going to find out that you were talking to somebody that didn't have the best information to share in terms of an opinion. Then obviously, if you elevate them or use somebody in the role as a testifying expert, then obviously that's what we've been talking about. They're there to assist the trier of fact, understand issues that are of relevance to the case, so that the fact finder can do what they're supposed to do, which is to quote unquote find facts. And the other thing that other role an expert can play, they can help you identify issues in the other side's experts, right? Soft spots in their testimony, soft spots in their experience, questionable assumptions that they've made to justify their opinion. So you can use, again, an expert in several roles, and it's not just in the role that we're talking about in the cases as a testifying expert.
Great, thanks, Marcos. Um, I'm going to turn next to Will to focus specifically on the farmed animal context, which is kind of a uniquely challenging area in which to work. Will, how do you go about finding an expert veterinarian in the context of farmed animal cases?
Yeah, this is kind of the million-dollar question, and I don't pretend to have all the answers. So, I would love if Chris and Marcos had thoughts as well. I would say start with the premise that it's hard, right? And I know I saw Darius asked a question in the Q&A about finding a mink expert. I can imagine that's probably really, really hard as well. And so, I think your first step is probably just to acknowledge that this is not going to be an easy feat. And I think the practical implication from that means start early. Don't wait till right before your trial or you've got a timeline. And so build out some planning and some opportunity to try to find that expert. From an agriculture context, yes, it's really, really hard to find vets. I mean, the industry has largely captured lots of veterinarians. Even in the cases where they're not captured, as I saw one of the questions in the Q&A, it's a daunting proposition to get somebody who might believe in what you're doing to sort of put their foot out there and say, you know what, I want to be the person to put my name on a declaration or to get on the stand and testify. So all of that to say it's really hard. And so then what do you do about that? Obviously start early. I think using your network and connections is always a good place to start. The animal law movement is a very small movement, and typically somebody knows somebody, even if that's not a person that can help you. They're probably going to have other recommendations. And so I try to come up with as big a list as possible and then just run down that stream and contact folks and see who can help. Vets, might not practice in that field, but maybe they went to vet school with somebody and they know somebody that practices on large animals or farmed animals, or there's a former classmate or somebody. And so using all those typical networks and connections certainly helps. I think along those lines, just as you get to know veterinarians, maybe even outside of the context of, hey, I've got a case, I need somebody. Anytime you're talking to a veterinarian, I think it's a good practice to find out what they know, what they don't know, what species they've worked with, and capture that information, log it, because you never know when you might need it in the future. There are definitely groups that have connections to veterinarians. I think Animal Welfare Institute has some veterinarians. I know the new TRAP group at ALDF sounds like might have some veterinary resources. PETA has contacts. Reach out to your friends at all those groups. And then maybe lastly, one area that I found useful in the farmed animal context is contacting local farmed animal sanctuaries. Many of them have veterinarians on staff or that support them. That's a tough predicament for those vets, but you know what? They might be connected to the network and they might have other people that can help. So, not a magic answer, but using all of your resources. And I see Chris got a hand up, so he's probably got something even more profound.
Doubtful, but I wanted to jump off what Will was talking about. When I'm looking for an expert, Will is often the first person I reach out to, along with Delcy and ALDF and PETA, and all four of them have been super helpful in connecting me with experts. And I think for all the animal law practitioners out here, one thing that would be really impactful to see developed and made more accessible is we all have this independent wealth of connections to a varying degree of experts. And I can say from my experience at the public defender's office, as well as national criminal defense organizations, they have the infrastructure. I can log on to when I was a PD, I could log on to the PD website and search by field and find a litany of experts with information on what their rates are, prior testimony, a folder of transcripts, and even large national organizations, criminal defense organizations, will often have a list of experts. So I think that would be something that would be super helpful for the animal law movement to really start developing, because it's really difficult to find expert. Will mention a comment by Darius in the chat, who works with me at the Animal Activist Legal Defense Project. So I'll just selfishly put out there, if anyone has any expert leads on mink, I would love to hear them, particularly those who are no longer in the industry, because that is a challenge. But oftentimes, some of the best experts are folks who came out of that industry, who are disillusioned or have had a changed opinion. And those can be quite effective. Sometimes you want to shy away from the ideological sympathetic um, vets just because they're really susceptible to being attacked on cross-examination. Sometimes we're forced to use an expert who has only testified as experts for animal welfare or animal rights organizations. And we just have to deal with that in cross-examination from the other side. Sometimes it's surmountable. The Foster Farms case, our expert had only testified for direct action everywhere, and it didn't really matter. Same in the Smithfield rescue trial, which resulted in acquittals. But I do think the strength, the point I want to come back to is animal lawyers should start towards developing a shared knowledge where we're not piecemeal trying to sort of figure out who our experts are.
Caitlin, if I
Um,
can,
yeah, go ahead.
sorry, can I just add one more comment that I just thought of? I think one other good thing to keep in mind, given the shortage of experts, is to where you can build for the future. And so maybe you have a low stakes case, and maybe there's a vet that's not testified before but has some expertise. To Chris's point, there's a very, very small pool, so whatever we can do to grow that pool is good. And so I've encountered no shortage of vets who are really sympathetic and want to do it. It's really just that experience is the hurdle, or sort of the this court thing is daunting. I don't know what to do. So I would say always keep an eye out for opportunities to kind of weave more experts in so that 5 years down the road, great, this person's testified 15 times. Here's another expert.
It
Yeah.
one. Oh, I'm sorry, Caitlin.
No, go ahead, Marcos.
Just one other, avenue for trying to find potential experts. It is time consuming to find, to find the right experts, to find somebody that A, that's willing to do it, B, that has the expertise. You can outsource that there are expert search services out there. It will end up costing more because they will charge a premium on top of whatever rate the expert is going to charge. But there's various services out there, and what they will do is you can leverage, them to bring you expert candidates that have you set the criteria. This is what I'm looking for. This is the type of case, type of expert. This is ideal. This is the unicorn. And they try to find that person, and they will present them to you. You interview them. You see their CVs. And the downside is it will result in some higher costs. These experts typically will charge an hourly fee, and then you're going to be paying a premium on top of whatever the expert search service charges on top of that. But you can use services like IMS, WIT, CLG or GLG, and they can help you identify some candidates that you might be able to use in your cases.
Yeah, and I've used those services for various matters before with varying degrees of
Yeah.
success. I think I tend to have better luck if I'm looking for a more traditional like damages type expert or like even like a cost of care expert. Veterinarians and animal behaviorists get challenging because they are worried about partnering with groups who they view as potentially controversial or risking like jeopardizing their professional reputations. And so, to that end, one thing that I wanted to add here is that I've had a decent amount of luck searching internationally, but then again, to Marcus's point, that increases your cost significantly because you're paying to fly the person back and forth to do site inspections, to sit for deposition, to testify in court, all that stuff. But especially with veterinarians, um, I've had an easier time finding ag veterinarians who are not captured by industry by going to the UK. I also wanted to add that one of our new transparency and regulatory affairs program that Brittany Pete heads, one of its mandates is to start compiling a very robust list of experts that we can then share with mission aligned individuals and organizations, and so it can serve as a resource for the broader movement. We also just hired a staff veterinarian who will help us in developing this as a resource. She's fantastic. Her name's Dr. Monica Bando. So my hope is that going forward, we'll be able to connect folks who are looking for experts with people through the database that we're working on building.
And just real quickly, just one fine point. I've had success cold calling vets. We have a case about steer tailing in Illinois that's going to trial in June. And just calling the big animal vets around the area has been helpful, and they have advantages that other national experts don't cost. There's always kind of a thing of the local flavor kind of has some credibility, so it's time consuming, but just start cold calling, and that's how what Will was saying we can cultivate more experts.
Great. Um, Thank you all for that robust discussion. I'm going to pivot to a new question now that I will kick first to Chris. Um, can you just give kind of an overview of some effective ways to prepare an expert in your experience?
Prep, and more prep. Um, you know, I typically will prep a defense witness no less than 3 times with pretty brutal cross-examination. I'll usually have another attorney who the expert doesn't know and come in and just try to go as hard as possible against them, just so they have that trial by fire. It's often helpful, and I have the benefit. I run a clinic at the University of Denver Law School, so I have students who aren't as sort of developed in terms of understanding the science. So they're coming at it from more of a position of how a jury would. And my goal is take this law student who may not be an animal lawyer, may be going into big law, who is taking our class, explain it to him or her. Because, in my own prep, I gain an understanding and the sort of the historical understanding of going through these issues. So maybe I'm not sitting in the best position as a witness. So I think just working with them to be like, explain further, treat me like I was just born, don't know anything about this, and having stand-ins. So for like big firms, have the paralegal who's not working on this case, have admin staff sit in. But that can be a really useful tool in terms of translating what might be super technical, confusing information into what ultimately you want the end product to be, which is a really simple explanation for any layperson to understand.
I want to take an audience question and for Marcos quickly, because this is going to lead to some interesting stories, I think.
Uh-oh.
In PW Tri-State, what experts did Tri-State attempt to present for testimony, and what Daubert or other factors led to the judge ruling that they were not experts?
Okay. So this is going to try we tried the case in 2018, I think. So they had a veterinarian, but the veterinarian and it was, was not versed in the species at issue. Um, they had no significant experience with big cats. I don't think they had any experience with lemurs. I think in the deposition that was taken by Zainab Graves when she was at PETA, I believe, and Caitlin, correct me if I'm wrong, that some of the information that she had learned about big cats came from watching
Oh, that was
Animal.
my
Is
deposition.
that your
Yeah,
deposition? Yeah, Animal Planet.
Yeah, so we were deposing the veterinarian about big cat nutrition. And so I asked her about the basis for her knowledge on like what the nutritional requirements for big cats were. And she said she had watched some documentaries. And when I probed that, I she came out with the fact that she had watched several episodes of Big Cat Diaries on Animal Planet, and they appeared to be eating rotting meat on that documentary, and that was the basis of her expert opinion. So
Yeah.
I had to try to keep a straight face through that deposition. I think I was successful, but it was really a struggle. And then we doubted her based upon that admission.
Yeah, that goes to, I mean, obviously she had the credentials, she had the license, but she didn't have the relevant knowledge, in the area that was at issue. And clearly that came out in the deposition. I don't remember the other experts. They had three, and they were all excluded, but the veterinarian was the one that was probably their most important expert.
Yeah.
And without a veterinarian, uh, it was difficult for them to challenge anything that our experts said. I mean, other than, through cross, and I don't think that the cross is particularly effective.
Yeah. And that veterinarian, I think we had to file Daubert and summary judgment at the same time or around the same time. And so we Dauberted her and then filed a summary judgment motion focused on the inadequate care that she found or that she provided, and then ended up winning summary judgment as to the failure to provide adequate vet care for when she anesthetized one of the cats to perform some procedure and then like failed to monitor recovery, and then the cat died as a result of that. So that was a partial summary judgment. We ended up taking the rest of the case to trial, but we won partial summary judgment based upon that vet's incompetence.
Yeah, that probably didn't help.
Yeah, yeah, for sure. All right. Um, I'm going to turn back to Will next. In a farmed animal cruelty case, what exactly is the veterinarian testifying to?
Yeah, so in our cases, we are generally acting as the prosecution, and so we are attempting to prove the elements of the offense. I would say two things. One, prove the elements of the offense, and then two, counter any defenses that the defendant might have. And so, in the context of cruelty, as far as proving the elements, that typically looks like, I mean, you have to obviously look at the statute, but typically we are proving that the animal experienced pain and suffering. And so, back to the Wisconsin slaughterhouse case I mentioned, a lot of our declarations were related to that. What happens when a steer gets their tail twisted and broken? What does that feel like? So we might be proving pain and suffering. We might be proving things like, in our auction case, was this animal deprived of water? So do rabbits need water? Do chickens need water in these types of weather conditions? We also might be proving things like, was that conduct necessary? Because that's a term that tends to come up in a lot of cruelty statutes. And then on the defense side, we are trying to disprove common agricultural exemptions. And so, was this normal conduct? Is this the way you're supposed to move a turkey? Is this an accepted practice for lifting that animal up? Is this the proper way to move a steer into the chute? And so, I would say, in short, it's really the elements of the offense as well as any defenses. And the most common defense would be the common practices exemption that's found in so many cruelty statutes. And so, they are typically interpreting what they're seeing on a video or on a record, and they're saying those facts, do they meet or not meet these elements? And then the other thing is not so much what they're proving, but they're providing context to the judge or the jury in whatever the case might be. In a lot of cases, the inside of a slaughterhouse is somewhere that people haven't been, or the inside of a turkey barn with 5,000 turkeys. And so providing critical context on why the animals are moving like that, why they're kept like that, plus proving the elements would be what we have used them for in the past.
Great. All right. Turning back to you, Chris, how do you deal with the other parties or the counter experts in a criminal matter?
Well, the first thing is you challenge them, whether your jurisdiction used Daubert or Fry or some amalgamation if you're in state court. You should always challenge them. And I think that's for two really important reasons. The first is to try to exclude them. And the second is you get to cross-examine them often. And that cross-examination, one, you're at a pretrial hearing, not in front of a jury, so you can take a little bit more risk in asking open-ended questions. And you can really get that transcript and you can use to effectively challenge their bias, their credibility. But one thing that I found has been helpful, especially in cases in which I don't have an expert of my own that's available. So the only expert that's going to testify is the state's expert or the opposition's expert, is try to figure out like what things will the other expert agree to try to make their expert your expert. And here's a really great example. We were trying to establish that our clients like sincerely believed and had reason to believe animals were suffering from cruelty. And ultimately, the state's expert, who ended up not testifying for other reasons, was countering that. And this was an expert who came from the industry. It was an industry hack. And so we interviewed her, which is another thing that you can do. You can just call their expert, and oftentimes they'll talk to you. And that's easier in a deposition, not so much in a criminal case. But we went through with this expert, and every reason our clients or our witnesses thought this animal is suffering independently, we got that expert to agree, yeah, that would be a cause for concern. And ultimately, the main conclusion was, would it be unreasonable for someone who is a vet tech, or who has experience to conclude that an animal is suffering based on A, B, C, and D? And the vet agreed, yeah, it would be. And then for other reasons, that vet ended up not testifying. We ended up not proceeding down that path. But those are some examples. So I think the important takeaway is challenge the expert, try to talk to them, get them on record or on a recording, um, admitting to things that you can make helpful. And it's not just attacking their credibility and saying they're a hired gun. It's saying, no, this person does have some credibility. There are some parts of their opinion that aren't credible, but there's a lot of things that they agree to that go to our point.
Yeah, just to add to that, I mean, research, research, research. Find out everything you can about the other side's experts. If they are, prolific experts, they have testified in other cases. You can, track down their transcripts, see what they've said, any public statements that they've made. If they're experts that play both sides of the fence, they do plaintiff's work and defense work. The good expert is smart enough to testify in a way that they don't box themselves into a corner, and they leave room to maneuver. And that room to maneuver, if they box themselves too, if they don't do a good job of it on a defense case, let's say, when they're on the other side of it, that could be used against them. And I've seen that happen. I mean, in terms of trying to vet experts, one time, unrelated to animal welfare, animal rights matters, found an expert that I thought was going to be great for us. Till I read one of his depositions in another case where he was testifying for the plaintiffs, and it was that was enough if we had used that expert and we had not found that, how do you deal with the other side's experts? They would have pointed to that testimony in another case, and it would not have been good. So research everything you can about the other expert, what they've said, and you'll be surprised at what you find.
Chris, did you have something else?
Yeah, to that extent, if you have a scientific study or some other authority that contradicts the expert, you can use that in two ways. Sometimes I will send the expert that report. I'm like, hey, I'm going to cross-examine you. You should read it. Most of the time they don't. So you get to do this big show of, well, we're going to have, you're on the stand. It's a 30-page report. We're going to sit here in front of the jury while you read it because I sent it to you 2 months ago and you didn't read it. Sometimes judges will say, yeah, you can do that. And the jury gets really pissed at the expert. The other option you have is the evidentiary rule of learned treatise, where you can just, even if the expert hasn't read it, if you get the expert to establish, and oftentimes you can do that during a Daubert hearing, that the journal is relied upon, is used in the field, you don't have to have the expert read it. You can just introduce the entire study or portions of it as substantive evidence under that. And that's like rarely used. I've only been able to use that once in my career. And I think even then the judge said that was the only time I've seen an attorney use it. So that's super helpful. And if it's cost prohibitive to have your own expert, well, maybe you can have an expert, or maybe an expert who's reluctant to testify, review the expert report and help you develop your cross-examination, even if ultimately you can't use that expert for a variety of reasons.
This discussion ties into the next question that I wanted to pose to Marcos, which is prior testifying experience necessary or even preferable?
I think it really depends. I mean, the most important thing is the expert somebody that has relevant expertise, and do they present well, and are they easy to work with, right? Are they responsive? Are they engaged? it's a double-edged sword. If they have, on the one hand, if they have prior uh, testifying expert experience, they kind of know the process. They've been, in the line of fire before. They understand what it's like to be cross-examined. They understand, how the process works. The negative is, they may come across as if they do it, if that's what pretty much they do all the time, they just come across as a hired gun. And the fact finder, may weigh that to some degree when assessing, whether or not they believe their testimony or not, or how much weight they give to it. The downside to having done a lot of that work, though, too, is that you have, they've made a lot of statements under oath, and they can, provide, rich, a lot of a rich environment for you to find information that you can use across that that can be used to cross-examine them and maybe diminish their effectiveness. Um, but no, it's not ultimately required. I mean, if someone has no prior experience, that's not necessarily a bad thing because one, for example, they have no prior testimony. Or they haven't written a lot of pieces like learned treaties or studies or articles, um, and so there's less of an opportunity for the other side to seize on something that they've said in the past that they can use against your expert. The downside, of course, is that they're unfamiliar with the process. Everything from how to answer a question to how do I write my report. And so you have to provide them with a little more assistance along the way. And it is nerve-wracking, I think, for anybody to serve as a witness, and especially where you're being called on as an expert to testify, in an area, and you've never done it before. That the other well, you'll find out that the other side's attorneys are not going to treat you gently. And so they need to be prepared for that. To Chris's point, preparing your experts, right? Mock examine them, even if they're experienced experts, always, do mock examinations, pressure test them, get them to experience what it's going to be like when they're sitting in that hot seat and they're getting grilled so that they're prepared and they're able to respond. So it's not necessary. And but sometimes it can be helpful, and sometimes it can be a detriment. It really just depends, you know, on that particular expert.
Great, thank you. Turning back to Will and back toward the farmed animal context, what are common challenges to veterinarian testimony in farmed animal cruelty or neglect cases?
I think the number one is what we've already talked about is just finding someone who can testify. And so I think we've kicked that one around a bit, but it's really finding somebody that has the skills and the experience and the willingness to do that. I would say another one, at least in the context of the cases we're working on, is that there's generally not an animal that a veterinarian can firsthand examine. So we're working off of undercover footage or we're working off of public records, and so the veterinarian is removed from the actual facts. And so they may not have the full picture of what happened. And so you try to counter that as best as you can. In the context of undercover footage, maybe you have the investigator testify first and they establish some other things, the context or what they saw that animal doing that wasn't on video, or maybe what was happening over here off of screen, or maybe how long this condition went on that you might not get from a just glancing at a video. In cases involving records or even others, we use FOIA quite a bit to try to paint a more robust picture. If this is a USDA slaughterhouse case, certainly we'll use inspection reports, but we might also FOIA emails back and forth between the USDA and the slaughterhouse that talk about corrective actions or what the breakdown was, and you can glean other information that can help paint the picture for the expert. So I think just not having that sort of firsthand view of what happened could be an issue. And then a little bit back to the first one of just finding someone that's got enough experience. I mean, it is very rare to say, hey, I've got a dairy case involving a herd of 8,000 head of dairy cow. Let me go find the vet that deals with that. I mean, those people are tied up in the industry. They don't want to do that. And so you do the best you can. You know, you find people that have experience that at least can be equated to some degree. In our auction, or no, it was the turkey case. You know, we're talking about turkey houses of 10,000 birds, and you know we found somebody that worked with flocks of 1,000 or 2,000. It was good enough. That was the best that we could do, and a lot of the experience and behaviors were translatable, and so I think that's something to just be aware of. And then I would say, lastly, one of the hurdles is just dealing with common agricultural practices. Since that term is generally not defined in a statute, there's some variability. And so it can be difficult to say this is common or this is not common. You might have to find a veterinarian that is familiar with lots of different industry guidelines, this organization, this government entity, and just having knowledge for a wide breadth of practices is certainly helpful. So those would be some of the big ones that come up.
Makes sense. I'm going to take another audience question from Chelsea, because I'm genuinely curious what folks have to say about this. So the question is, as a trier of fact, who tends to be more sympathetic to animal rights in the testimony of experts, juries or judges? And I would just add to that, like, what factors do you consider in deciding whether you're going to request a bench trial or move forward with a jury trial?
Well, I mean, it depends on the case. I mean, in the Endangered Species Act cases, you don't have a right to a jury, so it's going to be a bench trial. So you don't have to, make that decision. Uh, you know, uh, I mean, look, judges are human, right? And they're supposed to follow the facts and apply the facts to the law. But and that's supposedly what juries are supposed to do too. Um, Again, I think that that's idiosyncratic. It depends on the judge and depends on the jury you draw, and you're not really going to know how a jury sees the evidence until the end of the case. So that's just a hard question to answer. Um,
Yeah.
at least in the Endangered Species Act sphere, we don't have to make that decision. You get what you get.
Yeah, and the reason for that is that in the Endangered Species Act context, the remedy that you're entitled to is an equitable remedy. You get an injunction against whatever the conduct is that you're challenging. You have the opportunity to collect attorney's fees when you win, but you don't get damages. And it's that remedy at law, the damages remedy, that entitles you to a jury trial in the civil context. So that's why typically we don't have access to jury trials. There are some circumstances where we add in additional claims that would give rise to potential damages. And so we have the option to request a jury trial. But even in those circumstances, there are various considerations that we weigh, because oftentimes when you're suing these captive wildlife facilities, roadside zoos, you're in the middle of nowhere. The defendant facility might be buddies with everybody in the tiny town in your jury pool, or they at least, might be more likely to have the sympathy of the local population. So you want to look really closely at like who's sitting on the bench and, what inclination they might have toward the particular type of case that you bring. I would say, like, generally speaking, I think attorneys, I came into this job when I transitioned from representing corporations to representing animal interests, thinking that like jury would always be the best because you have the ability to kind of sway people with the story that you're telling a little bit more. But that hasn't necessarily really been my experience. We've had some very, very sympathetic judges who were very open to the stories we were telling, including the judge in our tri-state case. She was fantastic. Chris?
And this may come from just the criminal context, but almost always we prefer a jury. There are other reasons why we're not going to waive the right to a jury trial. I can count on one hand the amount of times I've waived jury and requested a bench trial in a criminal case, and those are really bad facts. But that being said, in my experience, I've had a lot of scrutiny from judges who kind of act as gatekeeper um, and are generally kind of cynical, right? So even, I will get really sympathetic comments out of the right side of their mouth, and then they ultimately screw me on that. And so I think jurors in the criminal context, we just kind of need one to at least hang the jury. But more importantly, our Foster Farms case, the Smithfield rescue case that our project didn't do because it predated our project. But going into both, everyone said we're in these really rural counties, Foster Farms, we're in Merced County, it's kind of a company town. But it was in fact the complete opposite, right? Where everyone hated Foster Farms because Foster Farms is not only terrible for the animals, but also terrible to the workers. And they were fantastic in terms of understanding that. And, because they don't get necessarily bogged down in the technical details. The only caveat to that is if the defense or the information is so hyper technical, sometimes that would be a reasonable reason to go in front of a judge. But generally, in my experience, especially in tough cases, jurors have, on balance, been better.
My
Makes sense.
answer is very similar to Marcos. In the context of private prosecutions, we are in front of a judge and we don't really have the choice for a jury. So you get what you get. And you would think that the law is in your favor and the judge is going to rule for you, but as was said, that doesn't work out.
Turning back to Chris, I think we have time for maybe a couple more questions at this point. Chris, can you just say a little bit more about how, in your experience, experts have been received by jurors?
Yeah, I mean, I think generally experts have been received favorably by jurors. And I think a lot of that is expert selection. The biggest concern beyond qualifications and the strength of the facts that the expert is relying on is the sort of hired gun line of cross-examination. And frankly, in a lot of our open rescue cases, our expert, in Zoe's case, one of the experts we were going to use was her mom. Because that just happened to be a vet that did an examination. And Sherson, who's an incredible veterinarian and frankly has testified very, very well and been well received by jurors, the cross-examination of her on her bias and her relationship to often the defendants has not particularly been effective. So one, I would encourage other animal law practitioners to go to Dr. Rosenberg because she's a great expert, but frankly, it'd be great to have her CV a little bit more varied in terms of that. It's just all about presentation, and sometimes I would say less is more. You want to sort of start at the most like broadest view of what an expert can communicate to the juror, and not just get super bogged down in details because you are storytelling. And that is the fundamental role of a trial of litigation is you are telling a story because stories carry the day. Stories persuade. It's not the hyper technical details. You look at that, how does that serve my fundamental theme and theory of the case, my story? Because at the end of the day, you do a closing argument or a summation or a motion for summary judgment. And the first thing when I think about writing those is what is my story? I'm not citing cases, I'm not pointing to the record. I write my story and then I fill it into what serves that story.
That makes sense. So we are unfortunately at time, so we're going to go ahead and wrap. I really am grateful for all of the panelists and to the audience as well for the fantastic questions. I really appreciate you joining us today.